it's Kativan, legal consultant and lawyer, and I'm going to tell you about real estate ownership types in Georgia. In order to understand the whole importance of the topic, we should mention some important aspects of Georgian law. First, everyone should know that it is prohibited for foreigners to buy an agricultural land in Georgia. Likewise, to attract foreign investments to its various industries, the Parliament of Georgia made regulations as easy as possible. A person can own different types of ownership at the same time. There is no restriction for amount of it. This topic is crucial and indispensable for individuals willing to purchase a real estate and make an investment in Georgia. According to law, we have two general forms of ownership in Georgia: sole, one person, and common is known as co-ownership, which means two or more people ownership. And there are some specific types as well. For example, Usufruct, Servitude, Superficies, and future ownership. You would know this keyword in Georgian in process of purchasing real estate, so seller provide you with real information and to be protected from scams and troubles. Okay, then we will start with Usufruct, or as in Georgian, Usufructi. Usufructi. It's when the property may be transferred to another person to use it as the owner, but with restrictions. Usufructuary can sell, mortgage, or transfer it by inheritance. The renting or leasing agreement requires the consent of the registered owners. Usufructuary exists temporarily or for the entire lifetime of the usufructuary. To continue with, the second type is servitude, or as in Georgian we call it servitude. Servitude. In this type, one property owner has certain powers over the neighboring property to use his real estate fully and properly. Servitude also allows the owner to prohibit other certain actions. The validity of the assessment is indefinite. Examples can be, for example, the right to use a well on the neighboring plot of land, or, for example, to build a road on a neighboring plot of land, and etc. Third, we have superficies, or as we call in Georgia, agnagoba. Agnagoba. It is in this case, the land may be transferred to another person for use with heritable and alienable right to build structure there, as well as the right to lend or lease such rights as well. Superficies only can be used on the land and not on any other types of property. It is valid for maximum of 99 years. We have the fourth type, and it's called future ownership. As we call in Georgia, momavali sakutreba. This is the ownership type when parties agree about the transfer of ownership to a buyer upon the prior payment, and the ownership transfers only after full price payment. If the buyer delays the rest of payment and the seller repudiates the contract, the parties shall return the performance rendered bilaterally. We have five kinds of ownership. It's called sole ownership. A person can have an individual ownership of an apartment and the other spaces of the building as well, for example, the garage. In this case, owner is only responsible and able to make decisions about the property, entering into a lease, the right to sell it, the right to manage it, to live in it, and etc. Finally, we have six type of ownership, which is called co-ownership. A person can have co-ownership, which means that the property belongs not to only one person, but to two or more others. They together have rights as owners and they manage the property with the common wishes. Only with agreement of all co-owners it is possible to change the legal status of the property. I hope you liked the video. Tell us about it in the comments. If you have any further questions or if there's a specific topic that interests you about Georgian property law, then leave a comment below and we will try to talk about it in the future videos. And lastly, don't forget to subscribe to the channel and hit the notification bell so you get notified every time we upload new videos. Goodbye, see you soon!